Hello, and thank you for joining us today. I'm Brett Osmond, the editor of Compass, and compass.info is Australia's national elder abuse hub. So you'll find lots of information on Compass. We'll be talking about some of that today. And one of the big topics on Compass is enduring powers of attorney. So I'm coming to you from Sydney. I'm from Gadigal land, and I'd like to pay my respects to elders past and present, and to welcome you all here today for what should be a really interesting conversation with John Chesterman, the public advocate in Queensland. So, John, thank you very much for joining us today and for being part of a conversation to hear what people need or want to ask us about enduring powers of attorney.
Sure, thanks, Brett, and good morning and slash good afternoon. We're in many different time zones. Still morning up here in Queensland and afternoon in the southern states. But good morning, Brett. Nice to be with you.
Wonderful. Now, this is the first, everybody, the first in our series on enduring powers of attorney for financial decisions. We're doing a Q&A for each state and territory over the course of the next few weeks. Tomorrow is New South Wales, and we're doing two next week and so on. So if you know of somebody who might be interested, you can go to Compass and have them register for the Q&As coming up. Now, the series is called You Decide, Who Decides? And it's a really good title, and it actually is the name of a national resource that is about to be updated. It's a resource you'll find on Compass. And it's produced by the Australian Guardianship and Administration Council, of which John is involved. But a new edition of that will be available in the next few weeks, along with some videos. It's an incredibly helpful, practical, simple guide to understanding pretty much everything there is to know about enduring powers of attorney. So if you've registered for today's Q&A, you will be sent a link to that when it is published. And we'll also be putting it on the Compass website. So, John, to kickstart it, I think I'd just like to let everybody know we're using the chat today to put your questions forward. So type them away, and I will raise them with John. I've also got a few questions which we'll use to sort of kick off the conversation. So, John, I've actually got an advanced copy of the new issue of Who Decides. You Decide, Who Decides in front of me. But thought it might be a good thing to start with, basically, if you could help us understand what is an enduring power of attorney for financial decisions.
Sure, Brett. So an enduring power of attorney for financial decisions is a particular kind of enduring power of attorney that enables the appointment of someone to make decisions on financial matters where the person themselves is no longer able to make those decisions. So we use the word enduring to mean that it endures beyond any loss of decision-making ability by the person. So it's a way in which you appoint one or more people to make financial decisions for you in the event that you can't make those.
And it differs from a general power of attorney, doesn't it? Because that can be done, say, for when you might have temporary loss of capacity, such as being in hospital or going away on holidays or stuff like that. So
yeah, that's right. And a general power of attorney is different to an enduring one. A general power of attorney doesn't apply if you lose the ability to make your own decisions. It's more like an agency agreement where you just get someone to do something while you're kind of out of the country, as you say, is a good example.
now it's available to all adults in Australia. Every adult has the ability to create an enduring power of attorney, but you do have to have capacity, don't you?
Yep. No, that's right. Yes, I was just going to say that same thing. So you have to have capacity to create the enduring power of attorney. And what that really means is that you understand what you're doing by signing it and understand basically who you're appointing and what that means, so that you'll need to demonstrate you understand that that person will be able to make decisions for you.
Yes, and it's not called an enduring power of attorney, is it, to everybody? There is Northern Territory call it by another name.
Yeah, we have a few different names that go around. The generic name enduring power of attorney is widely understood, but we have some specifics. So in Queensland, I'll speak from Queensland's perspective. In Queensland, we call it an enduring power of attorney for financial decisions and also for personal decisions, such as your health care or where you might live. Some jurisdictions call that an enduring power of guardianship.
Mhm.
That's not the term used here in Queensland. Yes, you're right. Also, in the Northern Territory, there's different terminology. In the Territory, they call it an advanced personal plan.
Yeah. So why make one? Why is it important for people to have an enduring power of attorney?
Well, simply because we don't know what might happen in the future. So you can imagine any situation befalling you. We hope it doesn't, but you can imagine that it does. It could be it could be one develops dementia and loses the ability after a period of time to make particular decisions. It might be something sudden, a catastrophic car accident, or indeed a stroke, or something that happens that renders you not able to make particular decisions. And so if you have an enduring power of attorney in place, you've already enabled someone to step in your shoes, as it were, and make decisions on your behalf, should you not be able to make those decisions. So it's basically, I say to people, life is uncertain. This is a bit of insurance.
And those sort of uncertainties, I think, well, people are aware that dementia is sometimes a cause of losing capacity. And but there can be other instances, can't there, as well? You could have a car accident or suffer a stroke, or I was quite surprised. I think there's a video that is published by the public advocate in Queensland that shows it's 1 in 65 people, supposedly as an adult, will lose capacity. Um,
Right, yeah, that'll be the public guardian up here,
yeah,
unless it's snuck its way onto my website.
it struck me as being much more, it's not something, that it doesn't happen. It happens to a lot of people.
No, it does indeed. And yes, once you reach, I don't have the demographic kind of details to hand, but once you reach a certain age, you, in fact, become at a very old age, becomes more likely than not.
Yeah.
Yeah, it's something we should all think about.
Great. Now we've got a question here from Catherine Middleton. She says, problems in the community with capacity being determined, people sometimes enacting an enduring power of attorney without evidence of individual losing capacity. So I'm assuming there, Catherine is talking about an attorney has an enduring power of attorney. The principal hasn't activated it yet. But what can the principal do to manage this type of a situation if they haven't lost capacity, but the attorney is already starting to use the enduring power?
So firstly, we'll just be clear on when you appoint someone, I'll just speak from the Queensland perspective. When you appoint someone to under an enduring power of attorney for financial decisions, you can choose whether they are able to act now while you have the capacity to make your own decisions, or contingent on some future event like you're losing the ability to make your decision. So you can decide the
Right.
default position actually is that the attorney is empowered immediately unless you specify otherwise. It's different for personal decisions like healthcare and decisions about where you live and so on. That's only activated when you don't have the capacity to make those decisions. So let's just focus on financial. So you can
Mhm.
choose, okay, but if you have that default position that it's active immediately, then an attorney can act immediately. And if they are doing so against your instructions or making decisions you don't want or something, you need to revoke it immediately. So end the enduring power. If it's, let's say, and this is more likely, Catherine's scenario where the expectation of the principal, the person who signed it, was that their attorney would only act when they no longer had the capacity to make particular decisions. And if they're acting much earlier than that, then again, the idea would be that the principal should revoke the instrument, and that's where you want to let the attorney know that they're acting outside of their power in that circumstance. And
Yeah.
in the end, the place to take this would be the civil and administrative Administrative Tribunal, which is QCAT in Queensland. It's the same in every state and territory. There's a similarly named Civil and Administrative Tribunal, which is the arbiter on these things.
Yeah, great. Thank you. Now, we have a few other questions, but I just wanted to ask a follow-up question to that, which is
Sure.
related to capacity. Who decides when you've lost
Yeah.
capacity?
So capacity is a legal term, but determining whether a person has capacity to make particular decisions will often be informed by health professionals. So we can have neuropsychologists and other health professionals who become involved. Sometimes you don't need to have a certificate. You can actually specify, if you really want to, that in your instrument you could specify in your enduring power of attorney that the attorneys only to have power to make financial decisions upon the receipt from a health professional of a certificate saying you don't have the ability to make decisions. You don't need to do that, and unless that's specified, you don't need a certificate as such. But if there is argumentation about this, ultimately it's for the Civil and Administrative Tribunal to determine whether the person has capacity to make their own decisions.
Great. Now, I just mentioned to everybody joining us today that there is a section on Compass called Understanding Capacity, if you would like to read more about that. We've got a question here from Penny Baker. What does the role of the witness play in enacting the power of attorney with the principal? For instance, the workability of specific terms, notably for a bank, or the quality of the instructions, such as attorneys signing prior to the principal.
Yeah, so the main role of the witness, and witnessing requirements differ throughout the country. Some jurisdictions require 2 witnesses, some 1. So here in Queensland, it's 1. And the role of the authorised witness is to not simply, and this is a problem we've had in the past, not simply witness the signature of the person signing it, but actually what they're doing is attesting to the ability and the capacity of the principal, the person signing it, to complete the document, which means they understand what they're creating by signing this enduring power of attorney, and that they're giving power to 1 or more people to make decisions on their behalf. That's primarily the role of that witness, and that's why we have a category what we've just called the authorised witness. It's not just anybody. They have to be satisfy certain thresholds. So in Queensland, they can, for instance, be a JP or a lawyer. That's what they're doing in witnessing, not simply saying, oh yes, I've seen the person sign, but they're saying the person understands what they're doing by creating this instrument.
Yeah, great. And we've got a question here again from Catherine. Is evidence required to confirm that the EPOA is legally acted upon, e.g. medical certification?
No, not as such, no. But if there is a dispute about whether the person has the capacity to make a determination, then QCAT is the arbiter. And Catherine's had a follow-up point, which is right, that waiting for a QCAT hearing to resolve may take time, and unfortunately things that happen in the meantime. Yes, indeed. If there is kind of clear wrongdoing here, so we're not just talking about areas of grey, but there's clear wrongdoing, that's where we're in the realm of notifying an agency that can take action. And in Queensland, the Public Guardian is able to take action in relation to alleged misuse of enduring powers of attorney where the principal, the person who signed it, has impaired decision-making ability. So that's where a report to an agency such as the Public Guardian or even the police in a clear case of kind of theft or something, I would suggest doing that as well. And Catherine's right that it can take time for a QCAT hearing to resolve this.
Yeah, great. Now, who should someone choose? Who makes a good attorney? And because it's a question often people ask, and with a document as powerful as this, it's really important, isn't it, to choose the right person?
It is absolutely, it's very important. The short answer is choose someone who you can trust. That's really the short answer. But then also think through how this would play out. So let's imagine that you've created an enduring power attorney for financial decisions. Can you imagine your selected person or people calling up the bank or going into a branch and really advocating on your behalf? Is that in their toolset? You can have lovely people who are, wonderful relations who you love dearly, but you just, oh, I just don't know that that would be their role. I can't see them doing that, whereas I can see this person doing that. So
Mm.
think about the role that they would have. I often say, if you're talking more about the personal decisions such as healthcare, who can you imagine in a hospital, a busy hospital environment, you know, asking the doctor to stop and please explain what's going on? Who can you see advocating for you like that? They're the
Mm.
people to choose. I very much counsel people against choosing uh, people, often it's their adult children, who they think might be offended if they're not chosen. And I often say anyone who's offended by not being chosen wouldn't make a good attorney.
Right. Yeah. Good advice. Now, I noticed in the you decide who decides, it suggested one of the things should be that the person lives close to you and would be able to do things in person, which is probably, quite important on a day-to-day level.
Yes, it can be. And
Yeah.
that's where you just think through, this is where it becomes very particular to the person. How complex are your arrangements? How many decisions do you imagine an attorney would need to be making? For instance, if you've got a very uh, intricate set of financial arrangements and investments and so on, that's one category. If, however, you've got the house you live in and one bank account or something, then you don't envisage there being heaps of transactions. That might colour your thinking as well. But think through what it is you're asking your attorney to do in the event that they're uh, taking up the role.
Now, there are some people who might be experiencing their own difficulties, which might make them not suitable candidates. So, what are the things people should be thinking about when they're evaluating? Because a lot of people choose family or close friends. They seem to be the default choices in a lot of instances, but there can be some warning signs, can't there?
There can be indeed, Brett. And I often say to people to examine your, let's say you've created one. Argue or suggest people look at this and review this every couple of years, because you might have for instance, adult child who unfortunately develops, let's say, a gambling problem. All of a sudden, that's a risk factor because we know gambling is an addiction, can be an addiction, and can lead to all sorts of behaviour. And an attorney has considerable power over someone's finances. So that's why you just want to think through: are there things going on in the person's life that might uh, make them not such a good choice to be your
Yeah.
attorney?
Now, we've got a few more questions that have popped up. So, Helen Wallace has put a great link for everybody
Oh,
to
great.
look at, which is a video about decision-making capacity. So, thank you, Helen. Jennifer Sampson has a comment there that she believes that an EPOA is not valid if the attorney signs and dates before the principal. Um,
Yes.
is that correct?
Well, technically, yes, because they haven't been
Yes.
appointed yet.
Yes.
Yeah.
Yes. Yes.
Yeah. Good point,
And
Jennifer.
we've got a question from Krista Gersh. Can the EPOA be changed from jointly or by a majority to severally for making decisions if the principal no longer has capacity? So I guess we should just jump
Yeah.
in there first of all and say
Sure.
you can appoint more than one attorney in Queensland, can't you?
Yes, you can appoint up to four
Up
in
to four.
Queensland. Yeah,
Right.
and they can be just for, I know Krista understands this, but just for others. So jointly means you're asking all the attorneys to agree.
Hmm.
Severally means you're enabling any one of the attorneys to make the decision on your behalf. That's why they're kind of legal terms, jointly and severally.
Right.
So you could have, as I do, I've got three children. I might specify I want all the children to agree on
Hmm.
something, but then you think through that might not be difficult, or might be difficult, or you might simply trust all of them and realise some of them might be busy at different times, and I'm just happy to have any one of them play the role. So there you point them severally. So the question though from Chris is, can you change that? No, you can't. After the person's not able to make any decisions, you'd need to take that to the tribunal for an order in that regard. But where the person does have the ability to change that, they can revoke the enduring power, make another one where they
Yep.
set it out the way they want it.
Yeah, I think I mean, a follow-up question is, I think one of the things that is important is understanding what you can and can't change and we've spoken a little bit about that. But essentially, once you've lost capacity, it's true, isn't it, that you can't change anything. You can't appoint any more attorneys. You can't change the details or instructions of your enduring power. It's sort of set, isn't it?
Yeah, one of the challenges, of course, is that increasingly in the human rights language, we're identifying capacity to be very decision specific rather than a kind of point in time loss of capacity. So that's my answer is a bit more complex on that score. But we do know people, for instance, with some forms of dementia will have capacity at certain times of the day to make decisions, but not at other times. So if you're wanting to change something, you need to have the capacity to understand what's happening and to do that. But indeed, if someone is, let's imagine the extreme scenario, someone's unconscious in hospital and they've signed the documentation, that can't be changed, obviously, by them. You need to take that to a tribunal to seek an alternative appointment if you think there's some harm coming from the enlivenment of their expressed wishes in the document.
Now, something else when you're thinking about choosing people is sometimes even thinking about their age. I know a lot of people tend to choose their contemporaries, their partner, or their good friends, but often they're the same age and potentially could lose capacity, at the same level or the same time as you. I know in my own personal situation, I've chosen a niece as a backup who is only in her 20s. So that can also be helpful to people, can't it, as well?
Absolutely, but I think that's very good advice, and I say to people also at my age, approaching 60, you want to have a GP who's younger than you too, because
Yeah.
if you want continuity of of care, but it is very much worth thinking about that, and oftentimes people who are in have a life partner, uh, they'll appoint each other often, but it's good to think about somebody else to play that role. And in my case, I've got an alternative brother who's older than me, and so yes, I myself should be thinking too about younger appointments for that
Yeah.
very reason.
Yeah. Now we've got a great question here from Catherine Middleton. What levels of documentation responsibility does an EPOA need to be aware of? Would an EPOA need to present evidence of how they have assisted the individual? I mean, I guess that speaks to how much detail a principal puts into their enduring power of attorney, isn't it? I mean, they're not, it's not a templated document in that you have to have everyone's enduring power can be different and have
It
different
can.
instructions. Yeah.
Yeah, it can be, and I think Catherine's getting to the roles of the role of the attorney and the due diligence of the attorney. That's where I think our requirements should actually be stronger than they are in terms of bookkeeping and so on. But as a matter of practice, you should keep obviously finances separate and utilize a separate bank account, keep receipts for things where the expense is on the principal's matters, and be quite. I mean, it's actually something that gives makes the attorney feel much better about their performance of the role too. Should anyone query them, and often it'll be a family member, to
Mm,
be able to demonstrate, well, this is the bank account I use for Dad,
mm.
and this is the book I keep all the receipts for that I spend money on his behalf under the enduring instrument. So it's very good practice to keep everything separate. And should there be any query about, for instance, the attorney, gaining financially from their role, then this can be used to rebut that.
Wonderful. Now, I notice in the You Decide Who Decides, one of the things that people could do is they could appoint an accountant to audit the attorney on an annual basis. I mean, there would be fees, of course, associated with that, but you can actually or you can instruct that kind of oversight, can you, if you want?
Yes, indeed, you can make it as bespoke as you like, and it is this gets to the issue too about it's good, I think, to get advice before you create a document, because you do want to think through sometimes some unintended consequences that might come. But I mean, one of the obvious consequences you refer to, Brett, is that there will be a charge to do that. But if you have reason to want that to happen, then absolutely put that in the instrument.
Yeah. Now we'll take a few more questions and then I've got a few about, what if you don't have a person and what
Sure.
forms you can use. But there's a good question here from Krista again, saying the bank requires all attorneys to be present for decisions. Is that the case in Queensland?
Not necessarily. It does. I mean, certainly initially, if they're going to recognise the instrument, they want to be able to do due diligence on who the person is and what's the instrument for which they've been appointed and so on. So they'll need to cite that, obviously.
Hmm.
But then things can be transacted remotely, but after that, has been set up. And they've got to be sure that the person has the authority to do what they're purporting to do.
Great. Now, the next question is from Holly McDonald, and it was one I was going to ask. It's a really good one, so thank you, Holly. What if you don't want to appoint someone that you know, or you don't have somebody that you trust? Holly said here, is the public guardian the best or only option to be a person's EPOA?
No, if you want to appoint someone to make financial decisions for you, you can appoint a range of professionals to the role, but that will cost.
Mhm.
So it's just worth bearing in mind, and indeed that the payment of them or in my view, to be included in the instrument too, that you're aware that that will cost. So yes, I mean, you're right in the sense that if you don't have someone you can trust, it is better not appointing, an individual who you've got concerns about. And there are agencies that can play that role who you can appoint, but they will require to be paid for that.
Yeah, yeah. We've got a question here from Melissa Burke. On a similar note, can you delegate specific responsibilities with an EPOA? Say, for example, payment of bills or disposal of property.
You
I
can be
guess,
very,
yes.
yeah,
Yes.
look, you can be very particular
Yeah.
as to what you want the attorney to do, and you can specify, indeed, you can specify that you don't want the attorney to sell your house if you're particularly concerned, that might be your major or only asset.
Yeah.
But there again, I do kind of counsel people to get some advice about putting things in there that may have unintended consequences.
Mhm.
For instance, if you say, under no circumstances the attorney to sell my house, and then suddenly you need access to money for some reason unforeseen, the fact that you've got that prohibition there means the attorney may have to take the matter to the tribunal to get authority to then sell the property if that's absolutely no other option in order to
Yeah.
pay for something.
Yeah. Okay. We've got a question here from Jennifer Sampson, which sort of speaks to, it's a really good question about, do you need to register your enduring power of attorney in Queensland? And if are there particular circumstances where it's required, such
Yeah,
as in this one, handling of real estate?
yes, indeed. So, if you're going to use the enduring power of attorney to make decisions about real estate, then yeah, it does need to be registered with the Land Titles Office. And indeed, it's the same in most jurisdictions in Australia. We don't, however, have a federal register. So in Queensland, it's Queensland Titles Registry. We don't have a federal register of enduring power of attorney. That's something I've strongly advocated for. That is still potentially on the cards, but for a range of reasons, including access to the document, access to the most recent one, ensuring that we're not relying on a previously revoked one. So the argument about registration at the moment, it is mainly in relation to dealings with land that requires it. Tasmania has a register as well for all enduring powers, but that's different.
Yeah. And another question here, this one from Thena Johnston. What happens when families are living in various Australian states? So enduring powers of attorney have different scope. The scope of the document is different in different parts of the country. And they're essentially run by the jurisdictions in each state and territory. So yes, what happens if, you as a principal reside in Queensland and your attorneys are in other parts of the country, or they even take you out of Queensland and move you to another state? Are there issues there that people need to be aware of?
Yeah, sure. So there's two things there. One is you're, for instance, resident in Queensland, you stay resident in Queensland and your attorneys are in other jurisdictions. They can still make decisions for you in the event that you're not able to make those decisions, to the extent that those are decisions that are germane to Queensland and your life in Queensland. If, however, and Brett, the example you give is a good one, where one adult child moves you to a new jurisdiction, all the states and territories have legislation that recognises appointments in other jurisdictions to the extent that that appointment could be made in that other jurisdiction. So they say, so to give an example, if you're taken to New South Wales legislation says to the extent you could make this enduring power in New South Wales, it's recognised in New South Wales. One of our jurisdictions, Western Australia, requires the State Administrative Tribunal, it's called over in WA, to have its eyes over the document before it will be recognised in Western Australia.
Great. Here's a question from Penny Baker. Where do you report the misuse of an enduring power by an attorney? Because, abuse can happen. It's one of the concerns people naturally have about appointing an attorney. So if you become aware of abuse, what are your options?
Sure. So I'll come to my reform argument in a minute as to we need more options here, in my view. So who term do you report the misuse? If it's blatant theft, which it can be under enduring powers of attorney, then the police are the place to take that. The public guardian in Queensland, and it's just in Queensland where this particular role exists, the public guardian has powers in relation to enduring powers of attorney, where they can look into the situation of a adult with impaired decision-making capacity for a matter, is what the terminology is. They can look into that arrangement. So there's police here in Queensland, the public guardian. I mean, the bank, tell the bank immediately that you have concerns so that they can put their eyes over this. My reform argument is, and this is something that the Australian Law Reform Commission recommended back in 2017 in its elder abuse inquiry, I recommend there should be an adult safeguarding agency in each state and territory to whom these reports could be made. At the moment, we have Commission in New South Wales, the Ageing and Disability Commission. We have an adult safeguarding unit in South Australia. The ACT has an empowered Human Rights Commission in this regard. The other state and territories are a bit quiet on this. So what happens sometimes in those scenarios is that a guardianship application is made for the tribunal to appoint someone to make financial decisions for the person, so an administrator to make financial decisions. But that's can be a long process and changes the decision-making arrangements, but often will be after the wrongdoing has occurred.
And anybody can make that claim, can't they? I mean, if you've handed your enduring power to multiple people who may not even be your attorney, so different members of your family or extended friendship group, and they become aware of misuse, anybody is able to make that report, can't they?
Yes, indeed. And that gets to a good point where we talk about, what are some of the safeguards people can put in place? I always say the best safeguard is visibility. So being visible and having your arrangements visible to others around you. So that's where you would say, you can even put this in the instrument if you want to do so, but where you tell others who aren't necessarily the people you've appointed, but you tell others that, I've appointed such and such to manage my affairs should I lose the ability to, but I want you to just check in every now and again to see what's happening. So it's quite good to tell others so that indeed if something does, in the unlikely event, but if something does go wrong, then that person can be an advocate for you.
Yeah. So that part of that strategy then would be sharing your enduring power. Potentially, what other places can you put your enduring power, make it available? I'm assuming your lawyer.
Yes, wherever it is, you want to make sure it's available
Yes.
at the time when it's needed. So, and I've been guilty of this in the past as well. Squirreling it away in a filing cabinet where nobody else knows it's there.
Where it is.
It will be of no benefit to anybody.
Yeah. Yeah.
So you want to make sure it is accessible.
Great. Now, I wanted to get to this particular question, which how do you make one? in Queensland? I mean, where do you start? I mean, what options are available to you? And what are the sort of recommendations that you would suggest to people when they start going about the process of making an enduring power?
Sure. So there are a couple of forms that are publicly available. You can complete them yourself, and obviously you've got to have the authorised witness and so on. You've got to sign it with an authorised witness, and there are places for the attorney or attorneys to accept their appointment. I do encourage people to think though about getting advice if they're in the position of being able to do so. There's quite a bit of literature available, including on the Compass website. But I do encourage people, if they're in the position to be able to afford to get a enduring power of attorney, if they want to get one done, it's worth paying some money if you have that available to get it done professionally, just to ensure that your particular circumstances can be taken into account. And as I say, the issue often is not that the person's unclear what they want, but perhaps haven't thought through some of the unintended consequences of putting that in the instrument. So you can, write various conditions that if they can't be met may mean the enduring power is void because it can't be operationalised. So just be wary of that. So the more complex the instructions and so on, the more likely one ought to get advice to do that.
Now, I just wanted to mention to everyone, we have a fantastic section on Compass called Enduring Powers of Attorney. There is a section within that solely on Queensland, and there's a checklist that you can access, which helps guide you through the process, along with suggestions, including getting, independent legal and financial advice. Just going back to some questions here, another one from Catherine Middleton. Would police or the public guardian also be the contacts for neglect, restricting, community access and possible other abuse?
Look, I mean, they can be, but it does depend on, because as Catherine would know, and I'm sure you're thinking of examples, there are areas of grey here where, absolutely, they can be the places where concerns can be raised about a person being shut off from society, for instance, and that's where it may be that a police report is appropriate and police can call and see what's happening with what authority is a person keeping someone from being socially engaged. Ultimately, those matters can find themselves at the tribunal for under guardianship applications in order to change and formalise decision-making arrangements where that's required. But they can be places where those concerns are raised for sure.
Now, the document itself has the word power in it, enduring power. So it can be that sometimes people potentially interpret that they become the decision maker solely for the principal. But that's not the case, is it? The role of an attorney is to be a supported decision maker for as long as possible. And if that is the case, I was wondering if you could talk a little bit about supported decision making.
Sure. So supported decision making is relevant to the operation of enduring powers of attorney in a couple of ways. So people would be aware supported decision making is a big human rights concept that basically is a set of principles that hold that people should be actively involved in all decisions that affect them, even those with impaired decision making ability. And there are ways we can support people who have some degree of impaired decision-making ability to make their own decisions. Firstly, why this is relevant is you may have an enduring power of attorney, which let's imagine for financial decisions, which specifies it's only to be actioned when you no longer have the ability to make your own decisions. We shouldn't just rush to that where someone has some impairment in their decision-making ability. We should still go to the person and work with them to work out, oh, might they be able to make this decision anyhow, and they don't need the attorney to step into the role. So that's the first thing. There are ways in which we can, work with, just give people a bit more time, a bit more information, they can make their own decision. And secondly, even where an attorney is active under an enduring power of attorney, there's an obligation. It's not a blank check for them to go and do what they think is simply in the best interests of the person. They're still required to do things that they think that the person would want to have done. So not simply go and spend it in the ways the attorney thinks is right. So in Queensland, the legislation requires the attorney to recognise and preserve to the greatest extent practicable the adult's right to make the adult's own decision, and if possible, support the adult to make a decision. So those things are very important when we think about the operation of enduring powers of attorney.
Yeah, and there's more literature and information available about supported decision making. That is increasingly the trend, and so Compass also has some really helpful resources there for people to access. Now, Jennifer Sampson mentions that attorneys, unfortunately, can be perpetrators of abuse, and I think it's an interesting conversation because elder abuse is probably more prevalent. In our society than a lot of people are aware. I mean, a 2020 prevalence study, national prevalence study, indicated that 1 in 6 older Australians in the community have experienced abuse in the last 12 months, and that financial abuse and psychological abuse were the two most common, and that the perpetrators of that abuse can be often adult children who potentially could be attorneys. So I guess this comes back to making sure you choose the right person, isn't it? Because
That's right.
trust is really the underlying security foundation of the process, but it's not a guarantee that abuse won't occur.
No, and we go back to the word power and enduring power of attorney. There is considerable power that comes particularly with the financial enduring power of attorney. And you're right that abuse can be rife. That national prevalence study, which incidentally it didn't look so much at enduring power of attorney because the people surveyed tended to be people who were still making their own decisions. Nonetheless, we know that abuse of enduring powers is rife and is a real danger. So the best safeguard is appointing someone you trust and reviewing that, as I say, every few years, because things can change in a person's life. But you need also, just in thinking about this topic, and Compass is an expert agency on this, we need to think about our how our society embeds ageism, because there are lots of situations where people justify their actions in, for instance, abusing their power and enduring power of attorney on the basis of what we call inheritance impatience. They think, I'm going to get it anyway, what difference does it make? Or indeed inheritance conservation, where they're worried about keeping mum and dad's nest egg rather than spending it on their well-being. So there are various ways in which wrongdoing can be justified that we need to challenge as well.
Mm, mm. Another question I wanted to ask you is, we here at Compass receive a lot of correspondence from people, and some people say they don't want to do an enduring power of attorney. They're concerned about the risks involved, but in the next sentence, also don't want to be appointed to a public trustee. I mean, at the end of the day, if you don't have an enduring power of attorney, what happens if you lose capacity?
So if you lose the capacity to make your own decisions, and there's a decision that needs to be made, and let's imagine in the financial realm, then the last option will be an application to the State Civil and Administrative Tribunal for the appointment of a decision maker. And even where that application is made, the preference is always to have someone appointed who knows the individual rather than a state body such as the public trustee. But that is a kind of a last resort appointment if there's nobody else suitable to play that role. So that's what can happen. So that's another reason to think about, well, as we have titled this publication, and its previous one, You Decide Who Decides, you get to appoint the person through an enduring power of attorney if you want to do that. If you don't have one, then that decision may be made by somebody else should it be needed.
Yeah, I mean, it might sound like an obvious question to ask with an obvious answer, but what is the difference between a power of attorney and a will? Because we even
Sure.
get questions where about this question, and there is a fairly simple answer, isn't there?
Yeah, that's right. An enduring power of attorney operates while you're alive, and a will operates while you're dead.
Yeah,
That's the simple.
that's
So
the basic.
will is a way in which you distribute assets after death. An enduring power of attorney ceases to operate on your death.
Now, how how do people know if making an enduring power of attorney is right for them? at the
So
end of the day?
yeah, no, that's a good question. So what I say to people is, if you think about your future, and let's imagine something terrible does happen, and you can envisage that into the future, and you know who you might appoint to make particular decisions for you. So let's consider, if you're of the view that, yes, I can see something might happen, and yes, I'm pretty sure I know who I would want to make decisions in that circumstance, then I do encourage you to think about creating an enduring power of attorney, because that ticks both boxes in the sense that you can see it might be needed for you, and you can see who you would appoint. Where, as we've said throughout this webinar, where you don't have someone you can trust, then it's better not to make the appointment.
Now, often these documents can be prepared years, sometimes decades before they're required. So things can change. How often do you recommend that people review their enduring power?
Yeah, so every 2 years is my recommendation to review. That doesn't mean, revoking and making new one. It just means having a look at it and saying, does that still hold for me? And then it's even worth thinking, and in fact, Brett, back to your point about the age of people you appoint, it's even worth thinking about, so at the age, you might create one when you're 40, and you might say, well, when I turn 50, I'm going to need to appoint different people. So for that reason of, wanting younger people to be able to play that role, so you can have certainty in that regard. So, but every 2 years is my recommendation there.
Right, every 2 years. And essentially, if you have created an enduring power of attorney, and say you live in New South Wales when you created it, but you've subsequently moved to Queensland, like many people do, and would you recommend making a new power of attorney because you're now a resident of Queensland?
Very good question, Brett, that I'm thinking about myself, because I made my enduring power of attorney in Victoria and then promptly moved to Queensland 4 years ago. I haven't made a new one in Queensland yet, but I was thinking that I would do so probably in the next year or two, because I'm comfortable with my appointment and I know it would be recognised here. But if you've moved permanently, it's not urgent, to the extent that if you're comfortable that with what you've done, and it's not something that's very kind of unique to the particular jurisdiction you were in when you made it. I just say that because those mutual recognition provisions apply to the extent you could make that document in the new jurisdiction to which you've moved. So if it's just a standard appointment, you don't have to do that urgently, but it is worth thinking about for sure. It's somewhat easier to present in Queensland to a Queensland banker document created in Queensland than to get the one from interstate recognised.
Right. Yeah. We have another question here from Jennifer Sampson. If a principal has no EPOA, is the public trustee and public guardian the only other options? I think we've answered this one.
Yeah,
Yes.
you can appoint other agencies and a lawyer or so on, but they will likely charge for that. That's a personal friend, but you want to incorporate, so you can do that, but you want to incorporate in the instrument the fact that this is going to be charged, and be aware of, that's where you want to have upfront conversations with them about what the cost of that would be.
Now, there can be misconceptions, can't there, among people who don't have an enduring power of attorney, that, oh, their husband or wife or adult son or daughter will be able to make those decisions. But actually, there'll be certain decisions that, unless they have the legal authority to make, that it's not just a default situation that they can or are able to. Is that correct?
Yes, it depends on what the decision is. We do have, in the health field, we have what's called an automatic statutory hierarchy of decision makers. So if someone's not appointed, there still will be hierarchy. We don't have that in other areas, though. So if a decision is needed to be made, and there is, usually we're talking about situations where there is some consternation about that decision. For instance, two family members in bitter dispute about whether their father should move into residential aged care, for instance, or sell the car or whatever, then in the absence of having appointed someone to be the decision maker, that may need to go to the tribunal for the appointment of a decision maker.
Mm-hmm. Now we're coming towards the end of our chat. Thank you very much, everybody, for your fantastic questions. I've got one or two
Yeah,
more questions. So if
no,
you do
great
have a
questions from
question,
people.
yeah, please put them in the chat now. We've got a question here from Penny Baker. Is there any further traction on a national approach to legalize decision makers to eliminate cross-border differences? And I guess this is about the harmonization of enduring powers of attorney laws and
Yes, so
documents.
that's one of my hobby horses, is the harmonisation of financial enduring powers of attorney laws. I've been advocating strongly for this. It is on the agenda of the Standing Committee of Attorneys General, who meet periodically. And so this is something, I often say, this is something nobody argues against, but it hasn't happened. And the reason it hasn't happened yet is that it does require all or most jurisdictions to modify the legislation in order to have uniformity. But I would like to see that there really, there's only kind of one area of policy difference amongst the laws in Australia on financial enduring powers of attorney. And I think we ought to be able to have an agreement so that we do have harmonised laws. I think that's very important. The reason it's very important is we would then more likely have standard business practices and be able to have clearer education for people about financial enduring powers of attorney and the role and responsibilities of attorneys. So
No,
it's
it's
a
a
hobby
really good
horse of mine.
question, Penny, too. And I just wanted to mention it can be complicated, and because there are multiple documents, the differences between enduring powers of attorney in each state and territory vary in scope. Some are only capable of handling financial matters, and
Yeah.
some actually take in health and lifestyle. So, if you want to read more about what is applicable in your state and territory, whether you need an enduring power of attorney, an enduring guardian, an advanced care directive, or information on wills, do go to Compass. All of that information is there, and you will basically be able to read about what is the scope or the requirements in your state and territory. And hopefully, yes, we can look forward one day to having a more harmonized approach to it. I've got one final question, which is around conflicts of interest, which is a big area, and that can inadvertently pop up for people. How do people firstly identify what a conflict of interest is, and how might they protect themselves or instruct in their enduring power to, have a remedy for conflicts of interest?
Sure. So that's a very good point, Brett. So you want to think about your attorney or attorneys, and might there be circumstances where they're asked to make decisions that would affect them? So I'm trying to think of an example off the top of my head, but where an attorney has a some investment scheme, and the principal has money in that or might put money into that, and the attorney might make a decision to invest some of their money of that's their father for under the enduring power of attorney. They want to invest something that benefits them. That is a conflict of interest, because the conflict is the person making the decision with the father's interests at heart or their own interests, and those interests conflict in that circumstance. So it is important for the principal to think about this in advance, and there may be even situations where they know that there's going to be a conflict, but they might say, that's okay, I do want to invest $1 million into X, Y, or Z, or $100,000 or
Yeah.
$10,000, and they can specify that in the instrument to avoid any concern. But it's a very important thing to think about. Some conflicts of interest will be apparent immediately, but some may emerge down the track. So you do want to be sure, and if you're in the role of attorney, let's say, and you're exercising powers under an enduring power, and some conflict has arisen that wasn't envisaged in the past, it is very important to get some expert advice on how to manage that conflict.
Great. Thank you, John. Now we're just going to take one last follow-up question from Jennifer. Her question, she said, should have included that the principal does not have an enduring power of attorney and no longer has capacity. Might the public trustee or the guardian be appointed? And I guess the answer is yes.
Yeah, yes, and that's an appointment by the
Yes.
tribunal, the
Yep.
Queensland Civil and Administrative Tribunal. So yeah, if you don't have the capacity to complete the instrument yourself, that's the body that has responsibility there.
Wonderful. Well, John, thank you so much. It's been a really interesting conversation. Thank you to everybody who asked a question and who joined us today. A recording of this video will be made available and emailed to you all, if not tomorrow, then the following day. We'll also send you a link to the new edition of You Decide Who Decides when it's available in the next week or so. But I do encourage you to go to Compass. There are lots of videos and short articles on a range of topics concerning enduring powers of attorney, conflicts of interest, how to choose an attorney, how to be an attorney, and specific information for Queensland. That's really, really important. So, and if you are in a situation where you are experiencing abuse, or are aware of abuse, there are services available on Compass that you can find in our service directory, which can be of assistance, including elder abuse helplines in each state and territory, along with the elder abuse helpline itself, which is 1-800-353-374. So thank you very much, John. I really appreciate you making the time. And
thank you, Brett, and thank you to our audience for some excellent questions.
yeah, wonderful questions, and have a lovely afternoon, everybody.